Good morning. I volunteered to tackle this topic with the longest name, identifying, understanding, and responding to racial/First Nations issues in our cases. It is a long name and it is a big topic, and so 30 minutes in no way is going to cover it to the extent that it needs to be. Because the challenge is, or the reality is, that Aboriginal issues and racial issues are incredibly complex, and it's difficult to explain racism and discrimination to people who haven't experienced it. I know this firsthand because I'm Aboriginal. My mother is Mi'kmaq, my father is Maliseet, and while my life has been greatly shaped by all of the good things about being Aboriginal, it has also been shaped by racism and discrimination that I still have to deal with to this day. And I know firsthand just how hard it is to explain that to people. It's probably one of the most uncomfortable topics to deal with in your life. It's kind of like when parents and kids have to have the sex talk. It's just really awkward. And if you're like my father, there are, those parents who say, well, my kids are just never going to have sex, so I'm not having the sex talk. And so there are also people who feel like, well, racism doesn't affect me, it's not a big deal, so I don't have to talk about it. Well, I'm here to tell you that it is a big deal. It does have something to do with your job, and you do need to talk about it. But it is hard. And so today I just want to look at it as a start to a conversation. And I picked one component of our job, a tool that we already have at our disposal, as the starting point to help you better get to the place where you're identifying, understanding, and responding to race issues, and in particular Aboriginal issues. And that tool is Gladue Reports. Now, Judge Derrick talked yesterday about how not a whole lot has changed since the Gladue decision in 1999 in terms of real impact on Aboriginal people. And in my opinion, I think part of that is because lawyers in the system are not using it to its fullest extent. For instance, in the last 3 years in this province, only 130 Gladue reports have been ordered, despite the fact that well over 700 Aboriginal people have been sentenced. I know many great lawyers, Crown and defense, who have 20 years at the bar, who have never ordered a Gladue report or participated in that process. Now, that's not coming necessarily from a bad place, but it is something that needs to be addressed. And the reason I chose this topic is because it does just what the title of this presentation is. It helps you to identify, understand, and respond to Aboriginal issues in our justice system. And I would suggest racial issues in general. Now, if you haven't read the Gladue decision, you should. However, I will give you a Coles Notes version of it for those who are new here and have maybe never encountered it before. So the whole point of that Supreme Court of Canada decision was to address Section 718.2 sub E of the Code, which says that the court that imposes a sentence must consider all other available sanctions to imprisonment that are reasonable in circumstances, and pay particular attention to the circumstances of Aboriginal offenders. So the court in Gladue was trying to give real meaning to that phrase, give particular attention to the circumstances of Aboriginal people. And the reason Parliament put that in the code, and the reason the Gladue decision says that we have to do that, is because Aboriginal circumstances are unique. They're unlike any other group of people in this country. And the reason for that is Aboriginal people have faced direct and systemic discrimination for hundreds of years in this country, unlike any other group of people, and at the hands of their government, at the hands of the Canadian government and our provincial governments. That's what distinguishes them. That includes things like the Indian Act, the Indian residential school system, and many other policies and activities that have forever altered the way that they exist in this country. And that discrimination has led to poverty, substance abuse, suicide rates, lack of education, lack of employment, opportunities that are far worse than what non-Aboriginal people face. It has also led to a bias within the criminal justice system, and the Supreme Court of Canada acknowledges that in Gladue and several other cases since then. That bias has led to judges denying bail, imposing more jail sentences and longer jail sentences for Aboriginal people than they do for non-Aboriginal people. This is where we get over-incarceration, over-representation at all aspects. I'm not going to quote the statistics because I'm sure many of you have heard it many times. It's in the media. But suffice to say, those are facts. over incarceration is real, and it's still real. And what Gladue says is that sentencing judges have a real role to play in remedying that injustice. Judges have the ability to change the way Aboriginal people are treated within our system. And so to do that, you have to give attention to those unique circumstances. Only in doing so can judges craft meaningful sentences for Aboriginal people that are meaningful for the offender themselves and for their communities. Only by considering those circumstances can you properly decide if imprisonment is going to serve that offender to meet deterrence, denunciation, all of the other principles. Now, I want to be clear. The Supreme Court of Canada says that 718.2 sub E doesn't give special preference to Aboriginal people. What it does, though, is give more attention to their circumstances because of the uniqueness. That uniqueness sometimes actually means that imprisonment isn't going to accomplish the purposes and principles of sentencing for Aboriginal people in the same way that it would for non-Aboriginal people. We have to look at sometimes alternatives like restorative justice or community-based dispositions. It also doesn't change the fundamental purpose of a judge to craft a sentence that fits the offender, fits the offense in accordance with the criminal code provisions. And so the court actually says there are going to be some times, and you should know this too, that some offenders are going to have a record that's so long, their crimes are so atrocious, that jail is going to be on the table for them just as it would be for non-Aboriginal offenders. That doesn't change, but it's how we get there. And that's what that consideration of those circumstances is all about. It's the method of analysis. And you also still have to consider length of sentence. Now, to be clear, there is no discretion in a judge having to consider those circumstances. They have to do it. The only discretion is about actually crafting the sentence. And the last thing I want to mention about that decision is it applies to all Aboriginal people. So it doesn't matter whether they live on reserve or off reserve, whether they are rural, urban, whether they're status, non-status Indians, it applies to all of them. If you're Aboriginal, you have a right to have your case considered with these principles. Now, I've put on the table a one-page handout of outlining the Gladue Report process. So there's a stack of them on the center of each table. I encourage you to take it because you need to be familiar with how the Gladue process works. And I don't want to go over it in huge detail because I think that the handout is pretty clear. But suffice to say, if you've never done it, it's kind of like the PSR process. Crown, defense, accused ask for the Gladue Report to be prepared before sentencing. Judge makes the order. It's the Mi'kmaq Legal Support Network in this province who prepares the report. The report gets completed, sent back to the court, and you consider it in developing an appropriate sentence. There's more information about that. What I really wanted to spend time with here, though, is giving you real-life examples of what Gladue looks like in practice. And so to do that, I actually sat down with two Aboriginal offenders who recently had Gladue reports done, and I wanted to get from them their firsthand experiences with this. So the first, they have given me authorization to share their experiences because some of it is in public, but they have asked that I not use their names. So the first is John Doe, who had a sentencing hearing in February of this year where a Gladue report was a part of it. And he was being sentenced for charges of assault and break and enter into a dwelling house. It was unoccupied, but as we all know, break and enters, custody's on the table. Our Court of Appeal is not sure how much anymore, but it's definitely on the table. And custody was definitely on the table for this guy because he was a bit notorious. He had 67 prior convictions, 8 of those were B&Es. He had been sentenced on 10 previous occasions, 5 of those were for custody. Not once on those 10 previous occasions did he have a Gladue report entered. Only once did he even have a PSR. Now I'm going to get to the why that happened in a few minutes, but I want to talk about what his Gladue report revealed about him. The court learned for the first time that John Doe's mother is Mi'kmaq, and she was connected to a local First Nations community, and she was interviewed extensively for this report. And what she said was that she raised John Doe and his siblings for a period of time on reserve and a period of time off reserve. And John Doe's mother grew up very much ashamed of her identity as an Aboriginal person. She remembers as a child parents not letting their kids play with her because she was Aboriginal. In fact, she was so ashamed that at the age of 16, she got married just so she could change her last name because her maiden name was a very well-recognized Mi'kmaq last name. That's how deep that shame was for her. The family, John Doe and his siblings, they were transient. John Doe's mother admits that she was an abusive parent, struggled with addictions. She had been abused as a child. All of that had been passed on, and she regretted it, but did acknowledge that it happened. The family was extremely poor. The Gladue Report got a hold of John Doe's school records and found that on one occasion, the school had to call home because John Doe was found eating food off the floor in the school. He was so hungry. He experienced racism himself. He first became involved in the system because his mom had left the family home and it was devastating for him. So he began couch surfing on the reserve and at one point ended up living in a tent in a pit on the outskirts of the reserve. The Gladue Report also provided a lot of information, general information about the reserve and Aboriginal people in general. So all of this got before the sentencing judge. It was considered with all of the other usual factors you consider, and ultimately the judge imposed a CSO. Now, I sat down with John Doe and I asked him, okay, well, what did you think about the Gladue Report process? And as you can guess, his first thing was, I got a CSO instead of jail. But in the conversation, he did actually identify a lot of other great things that came for him as a result of it. He said he first found out about Gladue Reports while he was serving remand, awaiting the sentencing, and he found out from another inmate. And so once the report process started, he became really curious about it. He started looking at cases and reading the criminal code, and while I was talking with him, he was actually quoting sections and cases that I didn't even know. He was that engaged in his court process for the first time. It had meaning for him. I asked him to compare Gladue Reports with PSRs, and he said when he had the PSR done, he actually felt like no one even really considered it. He didn't feel like his lawyer advocated for it. The PSR didn't tell any real stories about his life, and so the Gladue Report was much better than the PSR. I asked him to talk to me about the sentencing hearing itself where the Gladue Report was used, and this is what he said. He said, I was nervous to go to court that day. Every time I've been sentenced in the past, it was in front of that same judge, and every time I got jail. This last sentencing, I remember the most. The judge didn't ask me much, but I remember him looking me dead in the eyes and saying, I know you can change. I felt that there was genuine compassion there, and that was the first time I had ever felt that. I know without the Gladue Report, I would have gone to jail, but instead I got a CSO. When I heard that sentence, I felt like I was going to crap my pants and cry all at the same time. So it was very different for him. And it was different for the judge and everyone else in that courtroom. Since the Gladue Report, the author of the report has connected him with all kinds of services. He's actually started to become even more connected with his community, working harder to understand and regain his culture that he had lost. So it's been very significant for him. He's actually reconnected with members of the community that he had lost connections because of his involvement in the system. He was genuinely excited about his future. He said he didn't at any point downplay his criminal activity, but he said it's not going to define him. And he said he thanks God every day for his defense lawyer and for giving him a chance, because that Gladue Report was his chance, and without that defense lawyer advocating for it, he wouldn't be where he is today. Now, the second person I want to talk about is Jane Doe, who was sentenced on a number of breach offenses and had a Gladue Report in 2014. Now, her record was also a bit notorious, and she was notorious. She had about 18 prior convictions. Most of those were breaches, had been sentenced on 5 previous occasions. 4 of those were custody. And again, a Gladue Report never sought in any of those prior circumstances. She did have a PSR on 3 previous occasions. Her Gladue Report told us that she was Mi'kmaq and African Nova Scotian. Her father was Mi'kmaq, her mother is African Nova Scotian. And she didn't have much of a relationship with her father because he had suffered sexual abuse as a child, substance abuse issues. He was involved in the criminal justice system. So she didn't have much of a relationship with him. She lived with her mother. Her mother as well suffered substantial trauma in her life and racism as a result of being African Nova Scotian. They were impoverished. The most significant piece of information that came out of that Gladue Report was that Jane Doe was sexually assaulted on multiple occasions in her life. At the age of 9, she was molested several times by a family member. At the age of 12, she was raped by knife point. All of those incidents were reported to the police and had gone through the court system, but never were they ever acknowledged at any of her previous sentencing hearings. They were never factored in determining a sentence. Everyone knew about it, but no one talked about it. After these incidents of sexual assault, as you can imagine, Jane Doe developed addictions. She became transient, acting out. Her mother ended up placing her in foster care because she just didn't know what to do anymore. Jane Doe experienced racism as well as loss of culture because of the disconnect with her father. And again, the report talked about the two different communities, the African Nova Scotian community and the First Nations community. Jane Doe received a CSO, and when I asked her to talk about the benefits of the Gladue Report process, again, the big highlight was not going to jail, but there was also more for her too. She said the Gladue Report was far more detailed than any of the 3 PSRs that she had had. It was the first time that the sexual assaults that she experienced were really factored in to her circumstances and how they craft a sentence, including setting her up with resources. It was the first time her experiences as an Aboriginal person and as an African Nova Scotian person, including the racism she experienced, was considered by the court. And it was actually the first time for Jane Doe that she saw her family history on the Aboriginal side laid out in front of her. She'd never known it. And when she saw it, she realized where she had come from, how she had gotten to that place. But she also realized that she was doing better than the family before her. Her parents and grandparents had experienced far more trauma than even she had, so that's keeping in mind the sexual assaults. And so she realized it was getting better. As a result of the Gladue Report, she actually reached out to her father because her father was interviewed, and that report gave her a better understanding of who her father was, because before she just wrote him off as, you know, this incredibly negative person, but when she saw his history, she actually felt sorry for him and has been trying to rebuild that relationship. And it is complex because her father is still in the system, still struggling, but that connection never would have happened without the Gladue Report. She got connected with resources in the community and actually starts volunteering in women's groups in the community. Again, asking her about the sentencing hearing itself, she described it as actually being more strict than the previous times. She said the judge really was giving her the grills about, you know, are you really going to change? He talked to her differently. He was more engaged and she was more engaged. As for her current situation, she says she's in a really good place now, and the Gladue Report has given her a sense of determination to stop that cycle of trauma within her family and that cycle of poverty. She is a child, she's 21, she's a 3-year-old, and she says she's determined that that's not going to happen for her son. So now I want to return to the issue of why no Gladue Reports. Why hadn't they had them done before then? And the answer is simple and complex at the same time. The simple part is that no one knew, and in John Doe's case, no one knew he was Aboriginal. And the reason for that is he looks white. He looks like I look. And so assumptions are made. And that doesn't come from a bad place. It doesn't come from this, you know, deliberately, trying to be exclusionary place. It's just a reality. When someone doesn't fit our understanding of what a certain race should look like, we default to something else, default to white. And it happens. And quite frankly, I did it because I prosecuted this individual at one point, and at no point did I ever think to ask him, is he Aboriginal? And I'm Aboriginal. I've had that experience my whole life, and I didn't think of it. So if I'm not going to think of it, you're probably not going to think of it either. And again, that doesn't come from a bad place, but it doesn't mean that we shouldn't learn something from it. The complex part is when I asked John Doe, would you have identified had someone asked you? He says, I don't know. Because of the shame that his mom had, she passed that on to him. His mother taught him, don't tell people that you're Aboriginal. And I can relate to that because that's my mom's experience. My great-grandmother went to residential schools and was taught that there was nothing good about being an Indian. She was beaten, and that culture and that pride was driven out of her, so that when she raised her children and her grandchildren, they were taught, don't tell people that you're Aboriginal. So she didn't pass on the language, she didn't pass on the culture. And my mom says when she was a kid, growing up where she did, she said, you could have held burning coals to my feet and I never would have admitted that I was an Indian because nothing good comes from it. So I can relate to that. The other part of that shame factor comes from within ourselves. Because we have that disconnect from our culture and our sense of community, we don't have the culture and the language to the extent that we should. We've been denied that. So sometimes, as John Doe, sometimes he feels like maybe I shouldn't call myself an Aboriginal. Maybe I'm not good enough to be a part of it. The other part is there's a lot of focus on blood quantum, and he talks about that. It's one of the first things that people ask me when I say that I'm Aboriginal. Well, how much? You can't be a full-blooded Indian. That's none of their business, and it has nothing to do with what it means to be connected to a culture or a community. And so when people do that, you internalize it and you start to doubt and say, well, maybe I'm not Aboriginal, maybe I don't have a right to say that. And that's what John Doe's experience was. So he's not even sure he would have identified had someone asked him. Now in Jane Doe's case, people actually knew she was Aboriginal. She said on her legal aid application and in her discussions with her probation officer, she actually identified as both Aboriginal and African Nova Scotian. But still, it wasn't ever examined for her. And I think, and she thinks that part of the reason for that is she looks black. She presents as an African Nova Scotian and again doesn't fit what people think an Aboriginal person should look like. So people didn't explore it because they probably thought, well, she's not really Aboriginal. And she didn't know, neither one of these people knew to even bring it up because they'd never heard about Gladue reports. And why should they? They're not lawyers. And one thing to keep in mind is that the African Nova Scotian and Aboriginal community in Nova Scotia actually are closely linked and have been for years, so it's not uncommon for an Aboriginal person to have ancestry in the African Nova Scotian and vice versa. So it's a reality for this province. Now again, these don't come from bad places. These things were not terrible lawyers or terrible probation officers. It's just what happens when you make assumptions and when you don't know enough about those communities. So I'm hoping by hearing those stories, the benefits of Gladue reports and why I'm bringing this up is obvious, but if it's not, I'm going to summarize. Firstly, the whole point of the Gladue decision, which is talking about judges considering the unique circumstances of Aboriginal offenders, well, that was accomplished through those Gladue reports. And as such, meaningful sentences were crafted for those two people. Secondly, it was far more meaningful for them. Those two individuals, that was a life-changing process for them. They were reconnected with family, reconnected with culture, had a sense of pride, felt like they were really cared about by a system that had not cared about them for years. But the last point, and that brings me to the title of this presentation, is that we learn from Gladue reports. That bias exists in our system, whether you think it does or not. And so Gladue reports have the ability to inform. Now, a lot of people might think to themselves, well, I don't have a bias. The thing about racism, it's not all N-words and swastikas. It's usually very subtle and unintentional. I'm going to use an analogy, and I don't use it to make fun of the situation, but I think it's probably the best way I can convey it. Racism is kind of like a Taylor Swift song. Taylor Swift's music is everywhere. Whether you want to listen to it or not, it's playing on the radio, it's on commercials, kids are singing it, it's everywhere. So whether you like it or would ever choose it for yourself, you're going to hear it. And one day you're going to find yourself singing the song out loud. Like that Shake It Off song. I don't know how many times I caught myself singing that out loud, and I don't like Taylor Swift. It happens. Racism is the same way. It is a part of the fabric of this country. Stereotyping and assumptions about about Aboriginal people, African Nova Scotians, it's a part of this country. So whether you ever do anything to contribute to that, whether you ever believe in it or choose to participate in it, it's there. It's playing all the time. And one day you might act on a stereotype or make an assumption unintentionally. Now you have a choice. You can pretend like that's not happening. But we all know the only way to drown out an annoying song in our head is to change the music. Gladue reports have the ability to change the music in our justice system. It is putting a different dialogue out there for all of us to listen to drown out some of the negative messaging that we hear and have heard in this country for hundreds of years. Every Gladue report educates a Crown, a judge, and a defense lawyer, and potentially a host of other people in the system about the experiences of Aboriginal people. That's why I chose to focus on Gladue reports. But I also want to leave you with two other tips. Actually, before I leave the Gladue reports, that handout, I hope that you do familiarize yourself with it. A couple of other tips in terms of supporting that process is ask for every offender before they're sentenced, especially those ones that are going to custody. Don't leave it up to defense counsel to raise Gladue, because they're not doing it. I'm telling you that they're not. I'm dealing with legal aid in terms of improving that. However, there are things you as a Crown Attorney can do and say, are they Aboriginal? Has Gladue been canvassed? Just as a second check system essentially for it. The other thing is to factor it into your decision in terms of what sentence you're going to put forward. It will help you craft and better understand a sentence for an Aboriginal person. So again, the last 2 tips I want to leave you with that I think are practical. The first is you have to have an open mind. When race issues are raised in the context of your job, don't immediately dismiss it. Don't feel defensive. Use it as an opportunity to learn. If you do not have an open mind about this, you're not going to use Gladue properly, you're not going to use any of the case law properly, you're not going to be able to work well with Aboriginal victims, witnesses, accused, or the community resources available, you're not going to do your job. Because part of the job of a Crown Attorney is driven by public interest. That's the great thing about this job, is that we get to consider the public interest, but you don't get to pick and choose the public you serve. Aboriginal issues are complex, race issues are complex, but that doesn't mean that you discount it. In order to serve those communities, you have to be willing to learn something about those communities. So I encourage all of us to keep an open mind on that. The last tip that I would leave you with is ask questions. It's intimidating when a topic that you don't know about comes up. And if a race issue comes up, don't be intimidated to ask someone to help you with it. The Mi'kmaq Legal Support Network is a great resource. Their contact information is on there. But I'm also going to throw my name out there as well as a person you can always call when the race issue comes up. I have dedicated my legal career, and I continue to dedicate it, to issues of discrimination faced by marginalized communities. I have a lot of experience. I'm also closely connected with people who are even more experienced than I am. So if you call me on it, I will do what I can to answer it, and if not, I will find someone who can, because it's just that important. So on that note, I'm going to leave it there. If you have questions now, I'll answer them, but I don't want to take up anyone else's time. Thank you very much for your attention.